depending on when you're listening to this session on pre-contract inquiries. For those of you who've not heard me speak before, my name is David Keithley. I'm still practicing as a solicitor, but very much now concentrating on training and consulting rather than full-time practice, and I've been working in residential conveyancing since the mid-70s. So what I'm going to be covering today are these 4 items here in relation to pre-contract inquiries. Firstly, looking at the overlap, if that's the right word, between misrepresentation and pre-contract inquiries. And it's important that we don't lose sight of the fact that pre-contract inquiries are more than just a procedural part of a transaction. There is a significant risk underlying the answers which a client can give, and I'll show a few illustrations. There's also a possibility that solicitors can themselves be held liable for information given in replies to pre-contract inquiries, and again I'll cover that as we go through. And then we'll also have a look at the limitations on caveat emptor, buyer beware. It's often thought that that's a sort of overriding issue in relation to conveyancing transactions, but there are some limitations on the extent of caveat emptor, some of it by common law and some of it by actual legislation and regulations which have been introduced, which I'll have a look at. And then we'll have a look at some specific drafting points in relation to the property information form, and perhaps some of the limitations of some of the issues surrounding the property information form, and then look at the protocol and its impact on inquiries. And we'll also have a look at some issues in relation to inquiries relating to a specific issue of fire safety, and then finish off with a very quick mention of the Law Society's latest efforts, shall we say, in relation to reform of the TA6, but I'll come on to that at the end of the session.